Excellencies, distinguished guests, ladies and gentlemen, good afternoon. The next topic I would like to discuss is artificial intelligence and intellectual property. We discussed this morning in some very illuminating presentations the unique features of artificial intelligence, in particular, the fact that AI acts autonomously, makes decisions on its own, and we also looked at whether or not we can and should give AI its own legal personality. Now, for me, intellectual property law brings out those issues and really makes us think about what is unique about AI and whether we should be giving AI its own legal personality. Mr. Tanna showed you a slide where an AI system had created a painting. And a question that comes to my mind is, why should the AI system not get the intellectual property rights to that painting? So we'll be looking at questions like that over the next 30 minutes or so. I'll start off by giving an overview of intellectual property. I'm sure most of you are aware of what IP, intellectual property, is, but I'll just give a brief introduction. We will then look at the very interesting issues which AI creates in an intellectual property law framework. And there are two issues. How do you get IP rights over an AI system when AI is so complicated? And what happens when an AI system creates, for example, a painting? Who owns the IP rights in the painting? And we'll look at how else AI is being used in the IP world and where I think the future challenges will lie. So let's look briefly at what intellectual property is. The World Intellectual Property Organization defines IP as creations of the mind. That could be literature or art, inventions, and it can also be symbols, names, or images. Now, IP is very broad. And it's an important category of rights. Why? Well, the development of IP rights promotes social, cultural, economic, and technological growth. Many technological products that exist today only exist because of IP rights. The music and film industry functions because of IP rights. They are a very important set of rights. And the protection of these rights fosters creativity. Why would you spend many years developing a product if at the end of that process you launch the product and immediately the product is copied by a bigger competitor in the market? So IP rights encourages people to be creative, and it's particularly important for new technologies such as artificial intelligence. But as with all other areas of law, we need to find the right balance. If we overprotect rights, then there may not be an incentive to create technology. But equally, if we don't protect rights enough, then why would I create something in the first place? So we need to get the balance right, particularly at the start of a revolution like the AI revolution. You're probably familiar with the main types of intellectual property rights. Now, these can vary between jurisdictions, but principally there are three types: copyright, patents, and trademarks. And I just want to spend a few minutes talking about each of these. Let's start with copyright. Copyright applies to works or creations. And what we're talking about here are things like novels, poems, plays, newspapers, computer programs, films, music, paintings, even photographs. Now, there is generally no requirement to register copyright once you are the author of the work, and as long as the work is original, then you will have copyright over that work. And these rights can last a very long time. For example, an author of a piece of literature can have copyright in that literature for the whole lifetime of the author and even for years after their death. And the author has the right to license the copyright, to allow third parties to use the work, often in exchange for some money. So we see this in the music industry. Artists who produce songs will allow radio stations, entertainment companies to use that song in return for the payment of royalties or commission. Now, in an AI context, copyright may be relevant where the AI system itself creates something. So let's go back to the painting example. If a painting is created by an AI system, who is the author? Who has the copyright? Now, one answer, as we've discussed this morning, is the AI system itself. Maybe we should give the AI system the rights. But if we don't, if that is too ambitious at this stage, we need to decide who else has the copyright. Patents are very important when it comes to new technology. A patent is an exclusive right granted for an invention. And that could be a mechanical device, a new product, method for doing things, a process, manufacturing a product, or it could be a compound, so a way of combining things that hasn't been done before. The key to all of this is that the product, process, or compound must be new, novel, or inventive, something that nobody else has done before. And in order to benefit from patent protection, the patent right must be registered under the relevant law and with the relevant authorities. So here in the UAE, for example, there is a law called the Industrial Property Law, under which patents are recognized. And the UAE is party to the GCC patent system, which means that throughout the GCC, patents will be recognized and enforced. So if you are the inventor of a new product in Dubai and you register that product for a patent with the authorities in Dubai, you will have protection all around the GCC. Now, in an AI context, patents are very important. When a new company or an individual is developing AI technology, they will want patent protection. But we will come on to see the challenges of trying to obtain patents in the context of AI. Again, who gets the patent protection? Is it the person who designed the system? The person who provides the data and trains the system? If the technology is then sold to a third party, Uber, for example, does Uber have the patent protection? There are many difficult questions. Trademarks. These are distinctive signs that identify certain goods or services provided by a person or a company. These can be words, letters, or even slogans. The company name Kodak is a trademark. The Nike slogan, "Just do it," that is a trademark. They can also be drawings or symbols or packaging. For example, the Nike tick, that is protected by a trademark. And even colors, sounds, and smells can be protected by trademark. The Coca-Cola bottle is protected by trademark, and you've probably all heard the music that comes on with Intel. That music with Intel is protected by trademark. And depending on the jurisdiction you're in, you might also be able to register your trademark, and that gives you protection so that other people cannot use that trademark. Now, in an AI context, trademark is perhaps less relevant than patents and copyright, but we are still seeing areas where trademarks can be impacted by AI, and we'll come on to look at that shortly. So I want to focus on some interesting areas that AI affects IP. And there are two scenarios that I want to look at today. The first is IP rights over the AI system itself. So imagine you have created an AI system, you are very proud of it, and you want to protect it with intellectual property rights. How do you do that? We will look at that. Secondly, What if your AI system is itself creating things? We talked about the painting example. How do you deal with creations by the AI system? And I think that question is not yet as prominent as the first question, but as AI gets more and more sophisticated, more widespread use of AI is present, we will see that question being looked at in the future. There are three challenges, in my view, when talking about intellectual property and AI. The first challenge is dealing with the complexity of an AI system. And I'm using the diagram that I used this morning. And this shows the various components of an AI system and the various individuals that can be involved in the use of an AI system. And two issues emerge. Which part of the AI system is protected by intellectual property? It could be the whole system, but the problem with that is there are lots of different individuals involved. So how do you give this whole system protection under intellectual property law? That is the first challenge. The second challenge is the fact that, as we've discussed, AI acts autonomously. It creates its own code or model, it generates its own output, and there is very little human intervention. So how do you deal with this situation? One answer is, let's give the AI system its own intellectual property rights. And Mr. Tanna discussed just before lunch the challenges, but the potential benefits associated with that. And it really makes you think, if an AI system is capable of producing a master painting that, if it was produced by a human being, would have automatic rights, why shouldn't the AI system have the same rights? The third challenge is the fact that, as humans, we don't always know how the AI system is working and what it is doing. You've all heard of the black box problem when it comes to AI. As humans, we give it instructions, we give the AI system some data, but then the amazing processing power of the AI system kicks into operation. It reviews the data itself, and it makes its own decisions. But as humans, sometimes we have no idea what is happening in that process. We don't know how the AI system is working. In that situation, how do you give intellectual property rights over the AI system? If I can't even explain what I'm trying to protect, how do I get any protection for it? So it's this lack of transparency in an AI system which is the third challenge. So let's look at that first scenario. Imagine you have created an AI system, or you are part of the team that has created an AI system, and you want to acquire intellectual property rights over that system. You will have a strong interest in doing so because you want to have the advantage when you sell your product in the market. You don't want any of your competitors to copy your product, so you want to try and get IP rights if you can. You could try and get copyright. You could say the algorithm I have created to instruct the AI system to work is a work or creation in itself, and I should therefore get copyright. You're probably going to be quite attracted to the idea of obtaining a patent, because once you obtain a patent, nobody else can copy your technology for often 20 or 30 years in some jurisdictions. So you'll try to get a patent. Now, if you are the only person who has designed the AI technology, there are no other individuals involved, and let's say the AI technology is relatively simple to the extent it can be, then maybe you'll be able to persuade a patent office to give you a patent because you are able to explain the AI technology, and there is no one else who is entitled to any rights. But that is not often going to be the case. AI technology is inherently complex. You are going to sometimes struggle to explain how it works, and there will be other individuals involved who will say, I should also get some protection here and have the benefit of intellectual property. As I've said, you might be faced with arguments like, well, this isn't a work or creation. How can I give you copyright? Who is the author? Are you the author, or is it the other three individuals who are also involved in the AI system? And which part of the AI system are you seeking a patent for? You say you want a patent for the whole system, but the whole system is made up of many different complex parts. So how do I give you rights over the whole system? And just at the bottom of the screen there, you will see a provision of UK law that has generated a lot of debate. This is our patent legislation in the UK. And it says very clearly, a computer program is not an invention. And that means you cannot get a patent for a computer program. Now, you may be able to get copyright for a computer program because it could be a work or a creation. But what if you want a patent for your computer program or your AI system? How will this legislation be interpreted to work for an AI system? And for me, this provision gives rise to a big issue that judiciaries and legislatures will face around the world. How do we legislate for artificial intelligence from an intellectual property perspective? And should we legislate to allow people to have intellectual property rights in AI systems? I think the answer to that is we should, but we will have to draft legislation very carefully because at the moment, someone could argue that an AI system is a computer program, and in the UK, they won't get a patent. But in other jurisdictions, the provisions might be different, and you may be able to argue for patent protection. Now, just 2 months ago, the United States Patent and Trademark Office issued a consultation, and they are clearly thinking about some of the issues with artificial intelligence. And they have asked the wider public to answer some of these questions. And if you look at questions 1 and 2, these are exactly the issues that I have been discussing with regard to intellectual property. They have asked, what are the elements of an AI invention? For example, the problem to be addressed, the structure of the database, the training of the algorithm on the data, the algorithm itself. The United States Patent Office want to know the answer to this because they are struggling, as we all are, to identify which bit of the AI system deserves protection. Is it the whole of the system? And the second question, what are the different ways that a person can contribute to the conception of an AI invention? And what the United States Patent Office are thinking about there is the problem I've mentioned. With an AI system, there are many individuals involved. So which individual gets the rights? And they want to know more information about AI systems. And I expect that consultations and questions like this are going to be asked by many other patent offices around the world. I expect that national courts will need to consider questions like this when considering intellectual property. Now, I've been talking about all the problems with obtaining patents for AI technology. In fact, there are already many patents out there for AI technology, so the system is working to a certain extent. Since 1960, 340,000 AI-related patent applications have been filed. There's been a 28% increase between 2012 and 2017. And you'll see there, machine learning makes up 40% of all AI-related patent applications. And you may not be able to see the names of the companies, but just to put this into context and give you some numbers, IBM has over 8,000 AI-related patents in force, and Microsoft has around 6,000 patents for its AI products. Now that tells you two things. There is clearly a lot of AI development happening, and it has been happening for a while. Each of those 8,000 patents and 6,000 patents are distinct, so the technology in each is different. And clearly, the problems I've been identifying have been addressed to a certain extent. So it is possible to obtain patent protection for AI. I'm not saying it's easy, it certainly isn't, but it is possible. Then, the next question, and I think it's a very interesting question. Probably not so important now, but I think it will be in the next 10 or 20 years. What happens when an AI system itself creates something that deserves protection? It's already happening. Sony have managed to compose a song that was done only by an AI system. There was no human involved in the composition apart from setting up the AI system. Journalism. The Washington Post uses AI technology, a piece of software called Heliograph, to write stories and reports. So that is already happening. Computer games. Computer games used to be designed by human software engineers. Now, we rely on AI to design computer games. Why? Because the AI probably knows better than the human how to design a good computer game. What do consumers want from a computer game? How do I best use the graphics? And how do I best make the experience as enjoyable as possible for a consumer? Leave that to AI. It's better than humans in some cases. And finally, art. This is a very interesting story. There is something called the new Rembrandt Project, and it's a collaboration between a few organizations, and they have created an AI system which has produced a copy of a Rembrandt painting. And apparently, art experts struggle to tell the difference between an original Rembrandt and the AI-created Rembrandt, which I think really tells you about the power of AI and the opportunities in the future. But we immediately face the problem. If we can't give intellectual property rights to the AI system itself, who do we give them to? Let's go back to our diagram. Person A provides the raw data to the system. Person B is the architect of the algorithm. And person C is responsible for training the supervised machine learning system. Who gets the intellectual property rights? A, B, or C? Maybe they have jointly the rights in the AI system. And again, I'm going to show you a piece of UK law which tries to address this problem. And it says this: in the case of a literary, dramatic, musical, or artistic work which is computer-generated, the author shall be the person by whom the arrangements necessary for the creation of the work are undertaken. In other words, where a computer generates something, it will be the human whose work was necessary to allow the computer to do that who will get the rights. But A, B, and C, in our example, will all say that their work was necessary to allow the AI system to produce a painting or a piece of music or a computer program. They will all say, I am responsible, I am necessary for the AI system to do what it did. So they will all claim intellectual property rights. Now, it may be that all of them should have intellectual property rights. Maybe the AI system should have intellectual property rights. But this debate is going to continue for many years. And at the moment, there is no clear answer. Now, I'm not sure if any of you have seen this monkey before, but I will introduce you to a friend of mine called Naruto. And in 2014, a photographer, David Slater, was in the jungle and was setting up a camera to take photos of monkeys. And if you haven't heard this story, this is what happened. Naruto, the monkey, took a selfie with Mr. Slater's camera. Very clever monkey. The story continues. In the United States, an animal charity brought an action claiming copyright by Naruto in the photograph. They said Naruto, the monkey, should hold copyright in the photograph. No human being, an animal. Now, you may not be surprised to hear that the US courts, after some time, rejected the claim. They said animals cannot hold copyright. And maybe you will all agree with that. But it does beg the question, should animals have copyright? And if they should, why shouldn't AI have copyright or other intellectual property rights? So it's cases like this that are going to foster debate about intellectual property rights, and in particular, what Mr. Tanna was talking about earlier, whether AI itself should be capable of holding rights. And this is another example that is going to test that position. Just 2 months ago, a team from the University of Surrey in the UK submitted a patent application for their AI system, Dabus. And this AI system invented 2 different products. The first product was a food container, which was capable of changing shape. And the second was a revolutionary new flashlight system called the Neural Flame. Both inventions, both probably capable of having a patent. The team submitted the patent applications, naming the AI system as the inventor. So not the humans who designed the AI system, not the team from the university. They said the AI system is the patent holder. Now, we don't have the result of that yet because it was so recent, but that is a case that I'm sure will generate more discussion about whether or not AI itself should be capable of holding a patent. Now, the current legal position in the UK and the US is that only natural people, humans, are entitled to hold a patent. So it may well be that that application will fail. But, as I say, it will certainly engender discussion about this point, and you should all think what your position is. Do you think that AI should be given some rights? And if so, how can we facilitate that? Because it's discussions like this that will help reform this area of law, will help understand in the future how we grant intellectual property rights to AI. Just very briefly, by way of conclusion, AI is also being used to protect intellectual property rights. There are computer programs now that can analyze all patent applications filed around the world, and they can tell you if you are trying to file a patent for your product, whether you will succeed or whether you won't succeed. If you design some AI tomorrow and you want to determine whether or not you can get some intellectual property rights, you will need to be sure that your AI is different to everyone else's. But we've already seen that IBM have over 8,000 patents and Microsoft have around 6,000 patents. Is your AI any different to their AI? Well, there are now artificially intelligent powered tools that will tell you that, because these tools are able to analyze all patent applications filed around the world and tell you whether yours will stand a chance of success or whether someone has already filed a patent for your technology, in which case you might find it difficult. And AI is being used by IP agencies around the world to share data and to make the global recognition enforcement and protection of intellectual property rights easier to do. AI can do that because it can process vast amounts of data. And so that's the other area in which we're seeing AI affect the intellectual property world. So in the future, and by way of conclusion, I think we're going to see a lot more debate about the legal personality of AI. In my mind, if an AI creates a painting, there is an argument to say that the AI system itself should have the rights to that painting. So there will be a lot more discussion about legal personality in the context of intellectual property rights. I think we can see a lot more IP rights in the world of AI. I suspect in 10 years' time, IBM will have doubled the number of patents they have in relation to AI. And where you have patents, you will have litigation. There will be allegations of patent infringement, and that will generate a whole world of rights and claims around patent infringement. And as judiciaries and legislatures will have to do, they will need to consider whether existing legislation is good enough to protect AI technology using intellectual property rights, or if it isn't, how are we going to do that in the future? If it's new legislation, how do we draft that legislation in a way which properly captures the complexities and the difficulties and the uniqueness of AI? So this is a debate that is going to continue for a long time, and I expect you will all see lots more reference to intellectual property in the world of artificial intelligence. Thank you very much.